Well, good afternoon, everybody, and it's really nice to be back. Tamsin, thanks for coming back.
Thank you. Thanks for having me.
Lewis, as always, good to have you.
Thank you for having me.
You'll have to excuse us. We've just been having a reasonably robust debate about a particular part of the new legislation. I think it's sort of 30 all in tennis terms at the moment, but we'll come to that in due course. So for those of you who joined us a couple of weeks ago, thanks for coming back. You're probably mostly interested in a bit of a refresher and also what's changed since the bill became law. And for those joining us for the first time, we'll try and give you a broad understanding of everything as it passed through the Parliament. We've cut today up as best as we can over the next hour and a half. We've got a lot of pre-questions, which I'll try and get to some of them already, some exceptionally good questions. I have got the monitor in front of me. We'll be taking questions live as well. We'll do our very best. There's no way we're going to get through all of the questions we've already got, but we'll do our best to get to some of them as we go through. This is broadly the plan today. We started last time with bargaining, and I think we were a bit worried it became a kind of bargaining fest, so we've dropped bargaining back down a little bit this time. But before we get into that, I think the question everybody was asking me in the last 48 hours was, when does it all start? So we might just start there if you're all happy with that. So when do the changes start? Lou, do you want to kick off?
Yeah, sure. So certain changes started the day immediately after Royal Assent. So Royal Assent was 6 December. Those changes are some of the, I suppose, less controversial ones in a way. We have changes to small claims procedure. That is an opening up of the types of claims that can be brought in the small claims jurisdictions of the both state court, local courts and the Federal Circuit Court. Importantly, the regulation of pay secrecy clauses that we'll come to later has started immediately.
I think we'll do that right at the end, actually.
Yes. Rules pertaining to job advertisements, advertising rates of pay that are below an industrial instrument, provisions about how you can terminate EAs past their nominal expiry date. The time starts to run on the death of zombie agreements. The Registered Organisation Commission and ABCC are no more, effective from the beginning of this week. The initiation of bargaining, we're going to talk about an easier way to initiate single enterprise agreement bargaining. That has commenced immediately.
So we'll call that the old-fashioned bargaining.
Old-fashioned bargaining. Implementing or initiating that starts immediately, and the equal remuneration order provisions will start immediately as well. We won't go through them in detail because we're going to go through them.
Yeah, we'll obviously spend our time going through these. So that's off and running.
Yes.
But there's some stuff that's been deferred, and there's quite a lot that's been deferred. Do you want to start?
Yeah, sure. Sexual harassment. That one is not kicking off until the 7th of March. So this is a whole new arrangement, a new way for people to approach sexual harassment through the Commission, but we'll obviously cover that in a bit more detail later. And the introduction of these new panels that are dealing with gender equity and community care sector cases, unless they're proclaimed earlier. So there's a lot of these ones.
I'm hearing they won't be.
Well, then we'll see them in March.
I'm hearing there's still some debates about who's going on them. Which academics are being put on them. So I'm thinking it'll probably be that time. And then we've got 7 June. What have we got coming in 7 June?
Well, the flexible work arrangement changes. So we're covering
Which everybody's interested in.
Yep, and we're covering that first off. So We'll cover those, and then the penalties for pay secrecy clauses. So
there's a bit of a get out of jail free period in terms of not complying.
Yes, absolutely.
Yeah, so the rules commenced, but you won't have an offence or a penalty till 7 June.
And it's a big penalty too. So
keep going.
How about you keep going?
Okay. Then really the suite of bargaining reforms, these are the contentious provisions. These are the ones that will...
I love the way you say these are the contentious provisions. That's great.
These will commence either in 6 months' time, that is 7 June 2023, or possibly earlier if proclaimed by the Minister earlier. And so this includes arbitration of bargaining disputes, the new rules for EA approvals and the boot, single interest authorisation.
So this is the multi-employer bargaining world.
Supported bargaining world. So all of these provisions, including changes to industrial action, all of them will start together, and they will all start, as I said, either in 6 months' time or earlier if the Minister proclaims earlier.
So what's your bet?
Well, certainly not before March, I think. I think it's There's been no suggestion yet that there'll be an early proclamation, but I imagine between March and June is what I reckon.
What have you got?
Is it too broad?
What have you got? I've got a date.
I think it has to be sometime before June, because remember the original bill had 6 months and he amended it to give himself the power to proclaim it earlier. So he must be wanting to do it. So I would say March is a good date.
So my view is it's 1 March.
Right.
So that's my view.
I'm going to go 7 March.
Just to annoy me. Okay. Well, actually, I'll actually join you because I like a bit of symmetry. So it'll be 6 or 7 March. It'll be early March in my view. And the reason I'm saying that is that obviously I've been involved in a variety of, let's call them preliminary discussions related to multi-employer bargaining. And the union movement seem to think they're very confident that they can be operating in July. I can't see if they came in June, they could be operating in July. Now, maybe they're being overly optimistic, but I'm thinking 1 March. So that's what I'm telling most people at the moment. You wouldn't want to, you'd want to get your house in order by 1 March.
And the other thing to bear in mind here is that some of the EA approval process changes require the Fair Work Commission to issue a statement of principles.
Yeah.
And so I think there's going to be a bit of dialogue between the ministers and the department and the commission as well as to when the commission's up and running for some of this stuff. So that's why you'd think there'd be a couple of months breathing space
we've got one last one down the bottom, 12 months of royal assent.
Yes, so that's the limitation on fixed term contracting. So another topic of debate before the webcast, but you can enter into fixed term contracts with relish between now and the 7th of December 2023. None of the rules about fixed term contracting or prohibitions will apply to any contracts entered into in the next 12 months up till 6 December 2023. So any of those prohibitions only kick in to contracts entered into after 7 December 2023, and we'll probably talk about the interplay with successive contracts later.
And we'll see if we can settle the debate you were having before we go on here. And just before we jump into what's actually gone through the Parliament, we should let people know that as far as we're aware, there's a second tranche, and there could be there could be a third tranche,
and possibly a fourth,
and possibly a fourth. And at the moment, our information tells us that we'll probably see the second tranche sometime in, I'm going to say March.
Yeah, March.
That's our sense. So if you think this is a lot, please, whether or not it's going to cause you a lot of distress, it might do, just be very conscious that there will be a lot more to come next year in a variety of areas. And for some industries, I think what comes in tranche 2 might actually be as relevant and concerning or of interest as what's in the first tranche. So that's what we understand at the moment in terms of operability. So let's kick off. A lot of conversation about flexible requests. Now, these obviously aren't coming in straight away. There's a little bit of a hiatus here.
6 months.
6 months. I'm going to hand over the clicker to you.
Thanks.
If you're in control.
So we covered these last time, but just a refresher for people. Flexible work requests are changing. There are additional steps you're going to need to take before you refuse, if you're choosing to refuse somebody who makes a request. But
so the actual reason for the request, looking after a child under...
They all say the same,
Right.
except for 2 new additions. So one being that someone's pregnant, and the other that somebody is looking after immediate family or household member who's experiencing family and domestic violence.
And it always blew me away that those weren't on the list in the first
Did
place.
seem odd,
Seem odd. Yeah.
They say the same. What changes is how you have to deal with the request when it comes in. And the important thing here is previously you were able to give a reasonable business grounds refusal. There's nothing the employee could do once you refused. Now that has been opened up to the review effectively by the Commission. But 2 important things that you need to know as well is that when you refuse a request, you need to also consider what are the options you might be open to. So if someone says, I want to work 3 days from home, you need to consider, well, could I do 2 days or 1 day from home? And also when you refuse a request, you need to inform them that they have a right to have that challenged at the Commission level. So you're basically empowering them to do it at the point of refusal.
So it's a far more involved process now, first of all, in the sense of not only do I just explain that I've rejected it, I've got to explain what else I've considered along the way, and I've got to explain their rights to them about taking it forward if they want to.
And then if they challenge, you go to the Commission. Now the Commission might mediate, conciliate, but the big one is they have the power to arbitrate the decision, which means they might hand down a decision which says, no, you didn't have reasonable business grounds and you do need to comply with that flexible request, or they can order some other type of flexibility that might be possible in between.
One of the questions that came through is whether or not there's any special rules here for small business.
No.
Sadly, no. Sadly, no. We'll come back to where there are rules for small business, but on this one, there's no special rules. There's no special process.
I think the challenge for business here is to ensure that your business as a whole, your line managers, have a clear process internally that they know to follow. Because where I see the problem arising is that these requests might be dealt with improperly, hastily, without due consideration early on. And that's fine. The Commission might send you back to do it properly. But the problem is you will have already given reasons for refusal, not properly thought through or considered, and then you kind of prejudice your position to then reconsider it properly. And if you ultimately get arbitrated, there's going to be all of this kind of documentary relics that you've put in place that have poorly dealt with the request to begin with. So I think the message for our clients is if you're going to have these requests going to business managers, there needs to be almost a flowchart or a process spreadsheet that can be followed by whoever's dealing with it to say, step 1, do this, step 2, do this. You're going to need objective data or evidence available if you're going to put up a ground of resistance. Have you thought through what it is? And I think that's going to be the challenge, because what I envisage is a lot of people will stuff it up along the way. The Commission might not actually arbitrate the outcome to begin with. They might send them back through the process, but you've already tarnished your refusal so much.
Do you know the bigger problem before you even get to that? Because I remember when we argued the domestic violence leave case, that some of the evidence in that case came forward that only 4% of all flexible work requests are actually formal requests under the Fair Work Act. The great majority are informal requests. We should make a note here that we're still talking here about formal requests under the Act, rather than a worker saying, look, I've got this challenge, can we sort something out? And the employer says, yeah, I'm happy to sort it out, or I could sort it out this way or that way. So it's the first issue here is we're talking about formal requests, aren't we?
Yeah.
And so, you're going to have a conversation in your business about the distinction between a formal legal request under Section 65 versus the employee just coming to you saying, can we have a chat?
And again, I think that reinforces this need for everyone to have kind of a process to follow, which obviously we're assisting clients with, and we're putting together documentation to that effect. But that's the thing I think you really need to think about.
Particularly because that change in mindset, that it's not just about yes or no to the request, it's about what else can I offer, how else
can I, to put it bluntly, can I make reasonable adjustments? Can I accommodate? That's really the world we're moving into. Excellent.
Moving on to the next slide, and this is completely new. We didn't have this when we last discussed the bill. This is a Greens amendment that was put up and was agreed to by the Senate, and it's...
Is that why it's in green?
Just flagging for everyone that it's new, but it's very similar to the flexible work requests, but it's for employees who wish to extend their period of unpaid parental leave. So standard is people do 12 months, they can then request an additional 12 months. Currently, you can just refuse that 12-month extension. Typically on reasonable business grounds, you say, no, we can't do it. Exactly the same type of process that exists now with flexible work requests, or will exist from the 7th of June, will now apply to those requests. So where someone asks to extend, you've got to give it due consideration. If you can extend it for a shorter period, you can kind of put that forward. I can only extend you, say, for example, 6 months, not 12. And then you need to inform the employee that they have the right to challenge your decision if you don't want to grant whatever they're requesting. And it goes to the Commission in the exact same way: mediation, conciliation, or arbitration. And again, very broad discretion to the Commission. So I think similar to what you said about the flexible work arrangements, you want to have a really clear process and structure as to how to deal with those types of requests if they come in, particularly if you've got somebody to fill in for that employee while they're on parental leave. How do you deal with that? How do you stop gap, or maybe accept a shorter time period?
And again, is there any distinction between formal and informal requests? Because on this is one where it would be even more grey.
Yeah, exactly.
I am on parental leave. I am looking for an extension. I would presume that this is
well, the Act sets out a specific period of time in which they need to request it before the extension takes place. So it does need to kind of follow that specific.
You presume that this rule applies?
Yes.
Yeah, exactly. I'd accept that. Yeah. I'd accept that. Well, thank you to the Greens.
Exactly. Oh, I'm going to keep pushing on. Fixed term contracting. This is the one where we had a bit of a disagreement before we started, but
I had to call time.
I think we're now on the same page. We covered this last time, and the rules thankfully haven't changed, but there is still a lot of grey up for discussion for the Commission to determine. And it's really this 2-year rule when it comes to fixed term contracts. So essentially, any form of use of fixed term contracts or limited term contracts where you seek to use someone in excess of 2 years, you're probably going to be stopped from doing so. Where you might have a gap between, it's going to come down to this question of whether you have substantial continuity of the employment relationship between one contract and the next. So if you've got seasonal type contracts and you've got a big break of 4-6 months, it's unlikely that you will be stopped from using one fixed term contract for one season and one for the next. But where you might have contracts that roll on, for example, in the university sector where they finish up a semester and then might move to the next, that would be considered to be something where there's a substantial continuity of the employment relationship. So it would be covered by this kind of 2-year rule that applies to fixed term contracts.
And that test might be quite contextual. It's not necessarily purely about the time and the break. It could very much be contextual to what's going on.
Yes.
So if I was a tertiary institution, I had a 3-term year and I always do a term, it might very well be that from year to year doing one term, that might get me in, or are you going to say your break's too big?
No, I think what the focus is going to be.
This is the debate we're having off here. I wanted to bring it in.
The focus here is on the employment relationship. There must be continuity in the employment relationship. So if someone is not employed for an extended period of time, I think it's going to be very difficult to argue they have an ongoing continuous employment relationship. I think we're talking about gaps between semesters. We're talking potentially you end in December, you start in Jan-Feb. I think you could potentially cover that when there's quite a regular repetition of that engagement. But if someone works for semester one, goes off and does other things for the rest of the year and tends to come back semester one for a new fixed term contract each year, I think it's very difficult to argue they have a continuous employment relationship.
I suspect there'll be an argument about it.
There might be, but I think this is ultimately going to be resolved in the courts. And I think the focus will need to be on whether there is continuity of an employment relationship, substantially speaking. And I think we're really looking at trying to cover periods where there is a small gap and trying to cover periods where people might be trying to avoid the operation of these provisions by creating gaps. But broadly speaking, what this is directed at, I think we all understand, is periods where someone's engaged in a fixed term contract, it gets rolled over again.
And rolled over.
That's what this is directed towards.
And I must say, it reminds me very much of what happened when we started to focus on casual employment quite a few years ago now. You had quite a large number of employers who favoured casual employment for almost for ideological reasons, for no particular practical or commercial reason, who then changed their employment model. I think what this will do is it will challenge people as to whether or not there's efficacy in why they're using those contracts, or whether or not it's really just become a business habit. And I think that's the challenge.
And the other big one, and I'm not sure if it's on the next slide, is but just remember as well the 2-year rule. So you can't have one contract that extends beyond 2 years or multiple ones. But there is also a 3-contract rule as well, which is you can only have 2 successive fixed term contracts in a row. You can't have a 3rd successive contract, or you can't have one contract and then another that allows for an extension of its term. It's max 2 terms and max 2 years.
Yes, absolutely. There are some exceptions to this. There's quite a number, which we've covered off on the slide, but we're going to perhaps focus on the 2 main ones, which are highlighted in green again.
I think teal.
I actually disagree. I think it's turquoise.
Okay.
Okay. Well, the 2 most important ones are those who earn over the high income threshold. So currently 162,000, they are exempt from this rule. So if you want to keep rolling over your fixed term contracts for a high income earner, go and do so. The other one, which is, I think a lot of people might be thinking they might fall under, but I think is a far more difficult test to get over, is this idea that if a contract is wholly or partly funded by government funding, and the funding is for a period of no more than 2 years, and there are no reasonable prospects that the funding will be reviewed after that period, then you can have a contract that is longer than, or that rolls over. But no reasonable prospects is a very high bar to get over. I don't think it's going to be very easy. I think it'd be interesting to see what is required to prove this, but I think it's going to be a very tough thing for people to get under, particularly in sectors like university and the like, where it's pretty likely that they're going to be considered that work will be ongoing. And just a reminder again, though, that these these changes don't start until December next year. So you can happily enter into as many fixed term contracts as you like for whatever period of time you like. You could enter into a fixed term contract for 5 years today, and that would continue to be legal in 12 months' time and beyond.
I've just got a really interesting question. I'm just going to jump back in if we can. I really like the question. Do you think that the new Fair Work Commission process for flexible work request refusals is going to cause damage to workplace relationships? It's a good question.
I think it could. I think opening up that question about reasonable business grounds is going to be an interesting one. I think if you have genuine business reasons, then you would think you won't even end up in a commission if you explain that to the employee. But if you've been a little bit more relaxed and just have a policy, for example, that we don't let people work from home, and you've just applied that unilaterally, I think that's where the dynamic issues might come in.
Yeah, I think employers need to face some hard truths on this, which is that whenever an employee, and I've acted for employers for more than 15 years, whenever an employee seeks to pursue their rights, despite the existence of general protections provisions, there are employers out there, and it's not a small number, that start to view that employee in an adverse manner. It's just reality. And it starts to cause friction in the relationship. And for many, it can be the beginning of the end in terms of the relationship. And it can end up in a payout to leave, or it ends up in a termination event down the track. And that's a sad thing in a way, because there's general protections provisions to try and prevent that. But the truth is it does happen. And I think the reality for employees is it will probably only be those that really passionately want to pursue the request that will go that far, because they understand the reality as well, which is that when you ardently pursue a right that the employer does not necessarily want to accede to, there can be the creation of disruption and instability in that relationship. I think it shouldn't happen because it's actually unlawful that they will be treated adversely. It still does. And I think that's reality.
I think it's interesting because you've heard me say this many times before, Lewis, but when somebody's expectation of reality is actually different to reality, you inevitably have some conflict in the relationship. And so my issue with this is that the more you are able to have an environment of open communication, which is quite a safe environment to talk about things, the better off you're going to be in the first place. Because if you don't have that type of environment and you have friction, you're right, inevitably people start pulling apart and you do have damage in it. I don't think I'm going to blame the Fair Work Commission for that, but normally if you've got that far, it probably is an indication that things aren't as good as they should be in the first place.
Particularly because you could be causing trouble with whole categories of employees, just because you might have an issue with one. It could be all people who have, parenting responsibilities. Because you've got a blanket rule. Exactly. You've offended.
And just on that, and I think this is another area where employers need to be very careful, is this whole notion of a floodgates argument. I can't accept, because then everyone will want to. I don't know how well that's going to fly. If someone requests to work from home on a particular day, or to change their hours because of their circumstances, I think the Commission's going to look at that person's circumstances. I think this notion that if I accept this, everyone will want it, I don't think that's going to do very well in terms of an argument. So employers, again, they need to have very objective, clear evidence why they're going to be refusing.
But again, that anxiety is a legitimate anxiety, and if people have that anxiety, I'd be saying let's sit down and talk about the reality of that anxiety and what we might be doing before we get into that problem.
But remember, not everyone's eligible. Like, there's only very set categories of people who even have this right. I know a lot of people ask for flexibility.
Yeah,
hence
the informal versus the
formal. Exactly. So
sorry, I really took you off track there, but I thought it was a really good question. I'm going to hand back to you.
No, very good one. And I only have one little last thing to mention about fixed term contractors. Similar to the Fair Work information statement, we now have the casuals information statement, and we now have a new one called the fixed term contract information statement. Because we don't like bureaucracy
in this country, do we?
There's just another piece of paper that needs to be handed out. You need to hand it out. It will likely also be subject to offences for not handing it. So just important to put that as a part of your procedure, onboarding kind of processes. And similar as we put in this action item box, you have a long time before this commences. It's the longest lead time of any change. So you have a long time to think about your processes, think about whether you want to enter into really long fixed term contracts now, if that would be to your advantage. And if you don't, maybe look at whether you need to keep fixed term contractors in the way of your business operating.
And don't waste the 12 months, because we've got people starting to talk to us already I'd rather they be talking to us sort of in the next 2 or 3 months to get their house in order. Please don't ring us up in 11 months' time and say, gosh, I haven't looked at this. What should I do? Yeah. So please act early. If you are a big fixed term contract user, act early. Well, we might jump around with this a little bit. We'll wait and see. Look, first of all, what I want people to appreciate is that there are, in the new legislation, there will be 4 streams of bargaining. If you look at box number 1, as they say on the TV shows, if you look at box number 1, the notion of bargaining that we've always had, a company with their employees, be it 1 site, 2 sites of the company with their employees, that's still alive and well, and it's still kicking, but there's quite a few rules that have changed in relation to that. Box number 1. Box number 4, this notion of cooperative workplace agreements, multi-employer cooperative, in a way that kind of box was alive before, but it's been simplified and played with a bit. Box number 2 is the brand new one. That's the one that probably not only most people are asking a question about, Lou, but in some ways it was probably the one that got changed the most in the last little while, which we probably need to go through with some care. And box number 3 is similar to something that was already there, but it's been sort of streamlined to reflect box number 2. So we're now living in this world where we've got what we might call the old-fashioned form of bargaining. We're now living in a world where we've got multi-employer bargaining for the general marketplace. We've got a specialist multi-employer bargaining stream for people who are in what are called the supported world, and we'll use the word government funded for that, is probably the best way to describe it. And then we've got this cooperative stream. Just notice straight away that box 2 and box 3 cannot apply to the building and construction industry.
Yep.
I didn't notice, it's not actually been defined for the purposes of
it's linked to the award.
It's linked to the award.
It's not, it doesn't apply to those persons covered by the building and construction general on-site award.
But it's a little bit narrower than that, though. It's only certain parts of the award, and there are a large number of exemptions. So I just think don't think it as a catch-all. You don't want to be like, I'm in building construction. Definitely check the definition if you think that might apply.
Exactly. It's one thing I haven't read yet, but now you've just told me that I need to go away and read it. Well, we're not going to deal with box 1 by itself because that's what people have been used to. Although where things have changed related to that box, we'll deal with it. I'm going to knock off box 4 first, this cooperative one, and then Lou, I might hand to you to do the single interest, and I might then pick up supported if that's okay. So we've got this stream now called the cooperative workplace stream, and I want you to think of it very simply because I honestly don't believe this will get used very much, although I'm sure there might be some people who might think it's particularly attractive. But imagine this is an entirely voluntary world. You could imagine a situation where an industry-based employer association might very well go to the principal union in their industry and say, look, we'd kind of like to put together a template agreement for our industry or part of our industry. That agreement is approved, it's validated, and then basically employer by employer in that industry are going to have a vote at their workplace, a majority vote, to effectively voluntarily together sign up to it. And that's the world we're talking about with the cooperative stream. There's no industrial action allowed in this stream, so it's genuinely voluntary and it's genuinely cooperative. I actually think this could be a useful alternative to the supported bargaining stream, although I'm not sure the unions involved will think it's sexy enough for that. I think there could be a small number of industries who might actually think this is of some utility. Historically, many years ago, I know the bus industry had a look at this and played something similar. So there could be a few industries, but this is the entirely voluntary, entirely cooperative, non-industrial action stream. It's probably not one the majority of people are going to get involved in. Do you agree?
Yeah, I agree. We saw this in the cleaning industry about 5 to 10 years ago. There was the United Voice went out with what they called was a Clean Start Enterprise Agreement, and they convinced a lot of employers to sign up to it, and they actually did. This would facilitate that type of arrangement. That Clean Start Agreement hasn't really been used much recently. We could see that type of arrangement arise in some industries. Yes, but I suspect not most or not many.
Yeah, and it's a space worth watching, but I think for the majority of our clients and the industries we get involved in, it's probably not any great moment. And on that very brave point, I'm going to hand you the clicker because this is going to get complicated.
Well, it looks a bit complicated, and that's simpler than what the last version of it we had last night. Single interest bargaining is a form of multi-enterprise bargaining that is being made available to basically the workforce or the industry as a whole across Australia. So unions can try and bring in any types of different employers into it, but there are certain triggers and prerequisites. So what we wanted to talk about firstly is the life cycle of single interest bargaining. So if you think you're an employer, there's only going to really be 3 scenarios. You don't have an EA in place, you have an EA that's expired, or you're actually subject to an EA that is still in its nominal term. And we'll just talk about what the process is for each of these. If you do not have an EA, it is possible for a union to effectively come to your workplace and seek to have you bargain together with other employers if a couple of prerequisites are met. The first is a majority of your employees want to bargain.
So you have a vote or something like that.
Yeah, and it doesn't necessarily, the commission can use its own process to determine how there is a majority or if there is a majority. So there might be a petition, might not necessarily be a formal vote. If we look at majority support determinations currently, the most common form of approach is actually a petition with names.
And Mickey Mouse normally appeared on every one of those.
Well, the big issue with petitions is making sure that it's actually employees, not contractors or labour hire that are on them. So that's the first thing, is you need to have majority of employees in your business.
So no EA, I'm exposed to possibly being dragged into this.
Yes, that's right. Yeah. And so one of the prerequisites, as I mentioned, is this majority employee vote. The next is there does need to be a common interest between your business and the other businesses that are going to be part of this multiple enterprise agreement. Now, when we say common interest, what they call it is clearly identifiable common interest. It might be looking at the nature of your business, your geographic location, but there needs to be some commonality of some interests between the businesses. And in looking at that, there is now a new test which talks about the fact that there needs to be a reasonable comparability between the interests. So there's these triggers that need to be met in order for a single interest authorisation to be granted. But if that authorisation is granted, you are then in bargaining. And that's when you get to box 5. You have good faith bargaining obligations. You might be subject to protected industrial action. If you can't reach agreement, after a certain period of time, your bargain could be arbitrated for you.
And we'll come back to that.
And if you ultimately do have a document that you want to put to vote, you can only put it to vote with the agreement of all the unions that are involved in the bargaining, or alternatively, you need to go off to the Fair Work Commission, believe it or not, and get an order that says you can go to vote, and that order will only be granted if the Commission's satisfied that the unions unreasonably withheld their consent. So if this single interest employer authorisation is granted, you've got all of those things in box 5 up there bouncing around that will operate until you get to the making of an enterprise agreement.
So if I just summarise that quickly, 5 employers out there have common interests, all no agreements, could be the subject of a union running around, getting a petition at all of their workplaces, their individual employees, the majority of them say, we want to be a part of this. Union files an application to the Commission to get this authorisation. Commission goes, yes, I'm happy that all 5 of your employees said yes on a majority basis. I've had a look at the paperwork and the evidence, and I think there's a common interest between the 5 of you. Off we go, we're bargaining, and that's how it could work. So let's go back to box 1.
Yes, so now if you have an expired enterprise agreement, so you have an agreement that applied to your workforce and it's just expired, slightly different process. There is a 9-month period during which, provided you're bargaining for a new EA, you have a history of bargaining at your workplace, and provided that the parties are meeting good faith bargaining obligations, the Fair Work Commission has a discretion, so it's not automatic, but it has a discretion to decline to make this single interest employer authorisation for this period of 9 months. And that's 9 months after the nominal expiry date of your enterprise agreement. So you have this kind of 9-month window to try and get a new EA up. If you cannot succeed in that 9-month period to get a new enterprise agreement up, then at that point, what can occur is that the union can apply for a single interest employer authorization, and if they get it, again, they need to meet the same triggers: common interest, they need the majority vote, you need to have reasonably comparable businesses, it can't be contrary to the public interest. Provided you meet those triggers, then again, you're in box 5 again, and then we're back to bargaining again.
So one of the questions that's just come through, good question, and let's make sure this is clear, because I think you've said it, but we'll be clearer. The 9-month grace period can't be touched.
No, the 9-month period is a period during which the Commission can decline to make the authorisation even if those triggers are satisfied, that we talked about, the prerequisites. But once that 9-month grace period expires, those prerequisites are met. There's a majority of employers who want the multi-agreement, you're reasonably comparable businesses, you have some clearly identifiable common interest, then the Commission must make the single interest employer authorisation.
I'll give an example. Let's say that I'm a company who's been bargaining for the last 25 years and I'm on agreement number 14, and my agreement's just expired in the normal course and I've already issued the NER and I'm bargaining. I would think there's a very good argument that you'll get the 9-month grace period.
History of effective bargaining, right?
Yeah, well, that's one of the factors, and there's an object of the Act that promotes single enterprise agreements
anyway, so I think you'll be fine. If I've never done it before, it's my first time, and that might be different.
Well, you might not even have a grace period because you need to prove a history.
Exactly. So you're in trouble.
But what happens if you had industrial action last time? It was all took forever. You took years to get an agreement.
Well, my answer is that's what the Act provides for.
Are you getting the 9-month grace period?
Well, I think there will be a tension there because the Commission might form a view that you don't have a history of effectively bargaining, and so then all of a sudden you might not get it. That'll be a lot of.
Well, my question would be whether or not you actually create outcomes. So at the end of, forget process for a minute, but at the end of the day, so for instance, if you have a history of ending up with an agreement, and you've got, this is number 12 in a row, I think you've got a history of effective bargaining.
Well, yeah, it's interesting. It does direct attention to the efficacy and the effectiveness of your bargaining historically. So it'll be interesting to see how they apply that test.
Do we know anything about these words, the common interest and the...
Look, this clearly identifiable common interest appears to be a relatively low threshold because it talks about common interests plural. So it's not a holistic common interest
and
between your business. Well, that's a little bit more helpful because you need to demonstrate at least that it's reasonably comparable, the two businesses, which is going to limit these multis to people doing the similar type of work or similar activities.
Okay, but if we're in the same industry, does that meet the test, or am I literally looking into the specifics of the...
Well, I think it depends how bullish we are. We haven't had this debate yet. I think if it's just I'm in the same industry, I don't think that's enough.
No, okay.
You need to look at the nature of the business.
I don't think it's enough. So then again, what we're saying is if you have an agreement but it's expired, you've got this 9-month possible window here, but if you are not the beneficiary of that 9-month window, or after that 9-month window, we're back where the first group were.
Yeah.
So I've got an agreement, Lewis.
Yeah. So
it's got 2 years to run.
If you've got an agreement, you cannot be subject to a single interest employer authorization until that agreement expires. So you have a period of automatic protection for as long as your EA can operate, which is why we're already seeing right now a number of employers scurrying to make enterprise agreements, which in fact is what the government is saying it wanted everyone to do in the first place, which is to promote people into enterprise bargaining.
I think the minister himself actually said exactly that.
Yeah, that's right.
The minister actually said it. So for those people, we've been talking to clients recently about this in the last week, but if you want to stay where you are, rather than be exposed to the possibility of being dragged into multi-employer bargaining, your strategy now has to be, how do I do everything possible to ensure that I have currency of agreement, because currency of agreement keeps me out.
And currency at the right time. So you need to be looking at what else is going on in the industry. There's no point having an agreement now which expires in 2 years if all your competitors are expiring in 2 years because that's not of use to you. The question is, how do you sit with respect to the others that you might be tried to be fused together with? What you want is a staggering of your agreement terms with respect to other businesses that you
certainly
feel
your principal competitors, the major sort of people in the industry.
So that's going to be the key focus. So you are protected though. We've got a little small business coffee cup there. I assume that's indicating the small business cafe. But small businesses with less than 20 employees are also exempt from this regime.
With an agreement, not an agreement, doesn't matter, you're exempt.
Entirely exempt. But that test, just bear in mind, it looks at the entire group. It looks at any entities that are associated with or related to the entity to do the employee count. So it's 20 in the broader group of businesses. If you're less than that, then you're exempt from this regime.
And I think I should just call out some excellent work from the small and family business ombudsman Commonwealth, Bruce Bilson, around that to get that 20 in there. So really trying to support small business as best possible. And that 15 to 20, because originally the rule was 15, it's moved to 20. I know I had a lot of people come to say, well, is that really going to make a difference? And my answer is, well, actually, when it comes to cafes and retail shops, it really is going to make a very, very, very big difference. So if you're employing less than 20 headcount, you're out of this.
Yes.
Yes, and it's headcount. And
so it's totally fine to just try and enter into an EA if I've never had one before in order to try and avoid this world.
Yes.
No.
Yes. Why not?
No. If the purpose is to avoid it,
that's only for supported.
That's only for supported. Yes, you're right.
So it's totally fine in this world.
This world, yes, I can be as whatever as I want to be. So you'll appreciate that we're still having some debates. You're right.
Yeah. No. For single interest,
that doesn't apply, but that's for support. It's not in this stream. No. Okay.
So now the final element of this is that if
we've made an agreement. We've made the multi-agreement.
That's right. So if a multi-enterprise agreement has been made under this stream, the other thing that's going to be really interesting, I think this is where we're really going to see the application of these laws, is that a union can then seek to apply that multi-enterprise agreement to other businesses. And this is without a bargaining process. So what they can do is go to a workforce and say, we've made a multi-enterprise agreement over here. It's the whiz-bang multi-enterprise agreement. Look how good it looks. And what they can do is say, if a majority of you as employees would like this agreement, we can show that. And again, you have clearly identifiable common interests with the employers that are already on the agreement, and the businesses are reasonably comparable, and it's not contrary to the public interest, then we can apply to have your business roped in. And that process would then result in this multi-whiz-bang agreement that they'd already created applying to this new business. And that's what we call forced roping in. You could also do it by consent, so the employer and employees could voluntarily go through this process. But I think where we're going to see this more likely occur is a union might go and make a multi with 2 or 3 employers, and then they'll try and roll it out across the rest of the industry. And that's where the real teeth in this legislation lie, because it's going to be much easier for unions to do that than necessarily to multi-bargain across the board. And so that's the roping in process, and Nigel's going to no doubt talk about that when we come to support it. Now,
but can I just ask on the forced roping in, is there anything a business can do to say, this is not financially viable for me, I can't afford those rates, the terms don't work for my business?
So it's the same prerequisites. So as long, if they're not in their term, you're talking about the same prerequisites, which is clearly identifiable common interests, reasonably comparable public interest. That's the
so you got a public interest test, but the problem with the public interest test is the public interest test is like the highest legal test you can have.
But we're not actually looking at the individual business and how it's going to operate, their way of operating.
No,
this is what I think people keep asking.
I would think if you were going to go bankrupt, that would meet the public interest test.
I would think it would.
Yeah, I think it would.
But if it's just higher rates of pay that you don't particularly want to pay.
Too bad. Well, because remember, the whole purpose of this was to raise pay.
So that's single interest bargaining. What we've done is
if you've got a current EA, you're protected from roping in.
Yes.
Again, the brick wall that surrounds you in this is having a current EA.
Yes.
That's the important thing.
So that's single interest bargaining. What we've done for everyone's benefit is we put a bit of the content, that the actual deep detail in the slides that follows. We don't need to take you through it because we effectively have. So we've got that there for your benefit. And I think what we'll do is we'll move straight to support it.
Thanks, buddy. Now you'll see straight away that this diagram doesn't quite look like the diagram Lewis showed, although there's some similarity in features. So first of all, the supported bargaining stream is effectively, I'm going to use this phrase, it's effectively for those funded sectors. So you could initially think of childcare, you could think of aged care, you could think of some of the disability service sectors, social and community. There's a variety of sectors here which it's effectively aimed at, and just predominantly think state, territory or Commonwealth funded sectors. Now, there's some similarities you'll see in box 1, very similar blocks in the sense of, it's 3 scenarios: no EA, expired EA, current EA, and there's also an authorisation process. So straight away again, the same rule applies that Lewis talked about, and that is if you've got an EA and it's in its currency, it hasn't passed its normal expiry date, you can't be brought into this process. Now that's a little different to the last stream, because of course it's possible that there might be government funding on offer if you do participate in this process. So for some people, they might have a preference for staying out of it. For others, there might actually be a funding attraction to actually participate in it. So just be conscious of that. This is going to be a slightly different stream to the one Lewis talked about. But the same rule applies. Current EA can't be brought into the authorisation process. If you don't have an EA at all, or you do have an EA and it's expired, you can be the subject of an application for a supported bargaining authorisation. Now, straight away, very importantly, don't have to have a vote. There's no employee vote here, so they don't have to go through employer 1 and have a vote or get a petition employer 2. It's just an application from the relevant union, in this case, United Workers Union, the Health Services Union, or one of those. And the application goes to the Commission, and the Commission has to be satisfied that it is, quote, appropriate for the employer and the employees to bargain together, having regard to some criteria. And note, it's just having regard to, there's nothing fundamental about this. They have regard to what are said to be the prevailing pay and conditions within the relevant industry or sector that's under consideration. Again, the clearly identifiable common interest applies, but not the reasonable comparable test. That's not in here. So the common interest applies. The common interest is similar but not the same. It's geography, nature of the enterprise, but also, delightfully, are you funded by Commonwealth, state or territory government? So that's probably going to get you into common interest fairly quickly. And effectively, any other matter the Commission might deem to be appropriate. So you can see very quickly that for people in a supported sector who do not have an agreement or have an expired agreement, there is a very high probability that if you were identified in a union application for an authorisation, more likely than not, that authorisation is going to be granted. And a bit like Lewis said before, once that authorisation is granted and you're named in it, you're now moving into box 3, and so we're now in good faith bargaining. I'll come back to that in a minute. I got asked questions about that a couple of days ago. Protected industrial action is available. It's employee by employer, and all of the normal rules apply. Protected action ballot orders have to be employer by employer. So quite strangely, if there was 20 employers under the authorisation and the union wanted to do some industrial action, you might actually find 10 of the employees voting yes and 10 voting no. It could be quite a messy process. And as Lewis said, there's a normal voting process. There is arbitration available. We'll come back to that. And then your agreement gets made. And that's essentially it. You'll notice some features here that aren't on this slide, that were on Lewis's slide. Number 1, there is no small business carve-out. So that 20 employee thing doesn't apply to this sector. You will notice that the 9-month grace period does not apply in the supported sector. So there's none of that operating in this arrangement. We then move into what Lewis described before about roping in. We have consent roping in, and we also have force roping in. The test for force roping in effectively is what we've already described about common interest, but importantly, it's a test of it's appropriate to do so. And if you think about, is it appropriate to do so, that would be, is it suitable in the circumstances to bring this employer under this multi-agreement? And again, if you have a current enterprise agreement, you can't be roped in, you can't be forcibly roped in. So It's actually similar, but it's actually different in many key respects, and very importantly, it's different very much at the front end in that it's a lot easier to get an authorisation and get going. As we speak, a variety of supported sector industries are in discussions with the government and with various unions about the possibility of using this stream of bargaining and others on the basis of government funding being provided. We're in contact with most of those people, but if you are in a supported sector and you want to have a chat, please feel comfortable reaching out.
And this is where you can't enter into an enterprise agreement solely for the purpose
of avoiding
it. And so, how do you prove that? Well, I think people are going to look at, do you have a history of bargaining, your timing for entry? But you just need to think about that. If you're scrambling to enter into an EA right now to avoid this, you need to be a bit more strategic than that. And I'd probably give us a call, because you don't want to get your green EA and think you've got a brick wall, and actually it's a net with holes.
And it's going to be even more complicated than that, because if you raced off and got an EA, the next question then is if there is a funding conversation with government, is that funding conversation going to cover your personal EA, or is the funding conversation only going to cover the multi-EA? So unfortunately, as I'm saying to the people we're talking to in this sector, this is a far more complicated world. It's not just an IR world, it's a political world, it's a funding world as well. So this is going to be more complicated than just Bob, the transport company, wanting to maintain his enterprise agreement going forward. So that's supported by, and again, as Lewis said, we've put some slides there. Now, we might sound like we're against, I'm not sure if we sound like we're against multi-employer bargaining or for it, I'm not sure. I got asked the other day, is it a good thing or a bad thing? Beauty's in the eye of the beholder. It depends on who you are. If I was, and I'm just thinking now, let's generally rather than supported, if I was the highest payer in an industry and I had certain conditions and I had competitors chomping at me, taking away my market share, I might think it's a brilliant idea to create an industry agreement that reflects my conditions and sit down with the union about how I get all these competitors roped in so they pay my conditions and my rate of pay. I'm not being cynical about that. That would be in my commercial interest to do. And conversely, if I was one of those competitors, I'd probably want to be fighting that like get out of jail and just stay on my own as long as I can. There's lots of other things to consider as well, though, in terms of should I be in or should I be out. We've got a lot of clients who see their enterprise agreements as a point of differentiation, both commercially, but also in terms of their brand identity. So you need to think about that. You also need to think about, am I more or less industrially vulnerable alone or in a group? So there's quite a lot to think about before you say, look, this isn't for me, or it definitely is for me. And this is around the kind of strategic conversations we've been having with clients, and really they started a couple of weeks ago, Lou, didn't they?
Yeah. And what about that conversation with your employees? As in, are they going to even vote one up, even if they want to be roped in?
Well, and this is this whole debate that we've had now for the last years with clients about, do you have a transactional culture? Do you have a truly engaged culture? Unfortunately, a lot of employers overestimate the quality of their culture. But you're also right. I think there's a lot of employees out there who would say, well, hang on a minute, we don't want to be a part of that. We like what we've got here. We're fine. Conversely, I could see a lot of transactional culture where a union walks in and says, we can get you a 20% wage increase if you sign the petition.
Where do I sign?
Where do I sign? So what I will say is your culture could be taken out for a test. It really could be taken out for a test. If you don't want to be a part of this, it's really important to start to calibrate how effective your culture is as the defence, as opposed to just legal defences, because your culture is a defence as well.
Particularly as we go through difficult economic times. Like your employees, I would think, having an understanding of that and having an understanding of what higher rates of pay might mean for, frankly, their long-term employment prospects.
Yes, and the business's well-being as a whole.
Yeah.
And the business's well-being as a whole. So that's bargaining. Arbitration, and both of us have said now that at various times you can have arbitration. Arbitration applies to the general single employer stream. It applies to the single interest authorisation stream and the supported authorisation stream. And it's not particularly complicated. It's not particularly complicated as opposed to this 9-month rule. Lewis and I've had lots of debates about the goodness or the badness of the 9-month rule. There's a simple process now. Bottom line is this, is that if you can't get yourself sorted out, the presumption under this legislation is you'll go through a process of conciliation and arbitration to resolve your differences, as opposed to standing at 5 yards, slugging it out with strikes and lockouts. There's really a presumption here that you'll go through this arbitration process. And it really starts, first of all, with some conciliation, which is under the Act already, under Section 240 of the Act. And ultimately, if things aren't working properly, you get a declaration from the Commission that there are no reasonable prospects of the agreement being reached. However, Lewis, because we call this the Lewis Rule, I can't do this for a period of time.
9 months. 9 months after bargaining has commenced, or 9 months after the nominal expiry date of your enterprise agreement, you cannot have this arbitration process commence during that window. And so there is a time period you need to wait. If you're an employer who would like to move to arbitration, you're going to have to wait. If you're a union that wants arbitration early, they're going to have to wait too. And so you've got a 9 month period where you do have to slug it out, unfortunately. And I was a bit more comfortable with this when it was a 3 or 6 month period, because I think some employers might want to go to vote. They might want to have a crack at bargaining before having arbitration imposed on them. But now that it's 9 months, you can have employers really sitting there getting slugged with industrial action for quite some time and no ability to break it until that 9 month window expires.
And you know, I tease you about this clause because you were the original. I think you're one of the original advocates of the 6 or the 3 month process. I think for smaller employers who really don't, you know, who are probably scared that this is going to be a way of sort of wrapping me in. I'm not. You can't get a vote up with my employees, but you can use arbitration. It probably gives them some comfort that there's this period where this can't happen to them. You're right, though. We've got a lot of much larger employers who are very heavily committed in the domestic economy, very limited alternative sources of supply, heavily exposed to industrial action. I suspect they might have liked to have got to arbitration quicker because they can't always hold out for 9 months.
And I agree. And I think there's going to need to be some creativity here. There's a very rarely used provision of the Act. We've done it for a client before, but there is actually an ability to get cooling off periods. So it's very hard to suspend or terminate industrial action, but there are other avenues. You can actually cool things off for a little while, and that can buy you time during the 9 month period. So I think we might see that used a bit more for those looking to be creative to buy time during this period.
I also think we'll see the Commission more heavily involved in conciliation than it's ever been before. And I've often said to clients, you know, don't see conciliation as defeat, particularly heavy industrial clients. Conciliation is going to play a part. So look, at the end of the day, we could be in a world where we've got no reasonable prospects of success. We're past the 9 month hurdle. A declaration's been issued by the Commission. They've had a go at conciliating, can't solve it. They can give you a kind of last chance hurrah for conciliation. Otherwise, you're into arbitrating those matters that are not agreed. I suspect quite a bit might be agreed, but those matters that are not, it's a merits-based argument. Productivity is something they have regard to, but it's only one thing. And the arbitrated outcome is not required to improve productivity or operational efficiency. If you are likely to be heading down this world, there's an entire strategic consideration about how you position yourself. Please come and talk to us early about that, even before you start bargaining. I'm talking to a client at the moment about the possibility of positioning for this already, because it's likely to be where we end up. I'd rather have that conversation at the beginning rather than as we've already got in and we have to pivot. But arbitration is back. It's back. And they're laughing because I'm of a vintage where arbitration was what we did when we were younger, and they're of a vintage where it's really not been something they've done very much of. Well, you've done quite a bit, Lewis, to be fair.
I think I've said I don't think we're going to see that many arbitrations. I think
we never did in the past.
I think what we're going to see is a lot of conciliated outcomes. I think we're going to see compromise, and I think we're going to see both parties needing to yield more than they have before and being more realistic. But certainly for some there will be arbitration, and the spectre of arbitration will influence bargaining more than ever before.
And in many respects, you know, dealing with people who know how to manage that process, both strategically and tactically, is going to be really, really important, because there are ways to conciliate and there are ways not to conciliate. And it also might depend on the member of the tribunal you've got.
Absolutely.
And your knowledge of them and your experience with them as well. You're on boot, mate. You're on boot.
But I'll deal with it very quickly because it's quite technical and it hasn't changed largely from what we've discussed previously and has been, I suppose, part of our circulars previously. We've talked about the fact that there are better off overall test changes. The big change is that there's going to be a global assessment of terms and conditions as opposed to this line-by-line approach that people have experienced more recently in the Commission. There is also no obligation to consider every possible working arrangement, but more there's going to be a focus on reasonably foreseeable patterns of work and reasonably foreseeable employees. So that's the boot changes. What's really going to be interesting here is the reconsideration test. If employees start or employees have been working, they work a pattern that was not considered at the time of the boot, then all of a sudden they can seek a reconsideration to test whether the EA is still passing the boot. If you're working in building construction, if you're in manufacturing where you're paying 30 or 40% above the award rates anyway, it's probably not an issue. But if you're working in hospitality, if you've got an EA in some of the care sectors, if you've got an EA in one of those industries where you're actually paying just above award rates, this is a real issue. Because what might happen is you think your terms have been locked away for 4 years, but at any point in time they can be unlocked, reviewed, and the Commission can require you to up the terms and conditions across the board during the life of the EA. There's going to be a whole heap of pain associated with this reconsideration test. And I think when we're going to see it, as I said, it'll be retail, hospitality, care sectors. They're the ones that pay closer to the award. And I think that the focus for employers needs to be on what patterns of work they put up to the Commission to begin with, so you can demonstrate as many patterns as possible were considered to prevent the reconsideration arising. So more than ever, you're going to need support during the boot process to make sure you insulate yourself against the reconsideration test. So I think that's all I'll say about the boot. EA approval requirements, they're going to be changed. They're going to be simplified. That's the promise, because instead of a number of prescriptive requirements in the Act, we're going to be given a statement of principles by the Fair Work Commission. Let's hope the statement of principles ultimately is simpler than the prerequisites that were in the Act. There is a real danger it might not be, and that remains to be seen. But we'll have more to say about that once the statement of principles is issued, probably expecting that early next year.
And I suspect there'll be some formal hearing process about that, so people have a chance to comment.
One would hope so.
One would hope so.
EA terminations. They are changing. They've been a big point of contention. I know the Minister's mentioned it multiple times. There are now only going to be 2 ways in which you can terminate, aside from, we'll come back to zombies in a second. Termination by consent, so that's the standard process. You agree as the employer, majority of your employees agree, nothing changes there. But in terms of a unilateral termination, this is now far more limited than its previous use. So you're going to need to be able to prove one of the 4 things, which is either that there's a significant threat to the viability of the business, all of the 4 things, sorry, as an employer, a significant threat to the viability of the business. You're going to need to prove that it's likely to reduce the amount of terminations that your company is going to have to go through. In terms of redundancies, however, though, you're going to need to guarantee that the redundancy provisions in your EA will continue to apply even after the termination of the enterprise agreement. You're going to need to also show that it's appropriate in all the circumstances. And I think that that's going to be a very difficult thing to do, particularly around the viability of a business. Remembering also that there are going to be 2 other ways that you can terminate an EA, and that's going to be with the employees saying that it is unfair on them. And we don't know what unfair means. Perhaps not the same as unfair dismissal, unfair, but there'll be an ability for employees to also terminate. And then also, if you can prove that the enterprise agreement doesn't cover anyone anymore, you can also seek to terminate it.
So the bottom line is that we're kind of moving the clock a long way back.
So far back.
A long way back, where basically once I had an agreement, the only way I could get out of it was either with the employees agreeing, or basically I'm going broke.
Yeah.
And it's one of the reasons I'm going broke, and therefore get rid of this thing so I can continue to survive in my operation.
No longer going to be able to be used, I think, as much as a weapon in bargaining as it previously has been.
Yeah, and we could debate whether it was used as a weapon. My experience, and Lou, you and I have been through this now for so many years, my view was because we used to call it thermonuclear device in the sense of you don't do it lightly. My experience, it was normally we had nothing left to use because we just couldn't sustain the industrial action any longer, so we filed to terminate. This idea that it was some sort of clever, malicious tactical weapon that was thought up and we're all just working to use it in the first place. The minister's gone to town on that, but I'm not sure in the reality that was. But the fact is, that's all gone.
It's gone.
That's all gone. So what's a zombie, mate?
Anything pre-work choices, pre my time, to be honest. If you're under a zombie agreement, it's already started to die. It will be dead by
the pre-work choices, so 2005.
Yeah, and anything under the state enterprise, 2B type, they're also in the same category as these zombie agreements. They will all die a death on the 7th of December, 2023. 6 months in, though, you need to inform your employees that it's going to be dying. So just that kind of red flag administrative step. But they will end there unless you have entered into a new agreement, which means it won't exist anyway.
So just if I've got a 2009 Fair Work Act,
if it was made during the bridging period, it's subject to this sunsetting as well.
But if it was made after the bridging period,
then it's okay.
Then it's okay, even though it's really old.
Yes.
Okay, so it's really, really old stuff is gone. It's going. Really old might not.
Yeah. So bridging period for everyone's recollection, I think was 1 July to 31 December 2009.
No, that's right.
But basically, for those agreements that were made before that or during the bridging period or before, there is an ability to extend their operation up to 4 years if you've got really if it's appropriate in the circumstances. And what the Commission's going to be looking for is two things. One, it's not going to disadvantage employees when compared to the modern award. If the termination of the zombie would leave them better off, you're not going to get an extension. But if you can show that that they are still better off under your zombie agreement and that there's some difficulty in transitioning over the next 12 months, there is that ability. I'd definitely come and speak to us about the prospects of that succeeding, and you can work on an application. You've got to make that application though sooner rather than later, so you have the certainty as to what's happening to your zombie.
So look, I've got a couple of absolutely sensational questions, if I can, kicked in. They're sort of harking back, but we'll just quickly go through them. I'll take one, and I might throw one to you too, if I can. The interaction between single employer bargaining and multi-employer bargaining. You might just explain, once you're the subject of an authorisation, what you can and can't do.
Yeah. So once you're in multi-employer bargaining, so that is single interest authorisation.
So I'm subject to the authorisation.
You're subject to the authorisation. Or the supported bargaining or the authorisation. You can't then just go and make a traditional single enterprise agreement. You can't get out of that stream unless you go through a formal application process to be removed, which will involve largely all the factors that got you in there in the first place. So you can't just get out by making your own single enterprise agreement.
So if you're going to do that, you have to do it before you're subject to that authorisation.
That's right.
Great. And then we had a really good question about whether or not independent schools would be necessarily captured by the supported bargaining sector. Look, I'm going to say possibly. The way the legislation is worded, it does talk about being substantially funded directly or indirectly by a Commonwealth, state or territory. I think schools would be indirectly funded in some capacity in that regard.
But that's only one factor.
That's
they
only
might
one
even
factor.
Worked in because geography.
So look, just I'd say probably off the top of my head, I'd probably say yes. I think you're exposed to both those streams, but certainly you possibly could be exposed also to the supported stream as well. I don't think you're the primary focus. You're not.
No, because there's that. There is for supported also. There needs to be some assessment of market rates. Low paid.
Exactly right.
And I think there needs to be some argument about whether the market rates in that industry would warrant intervention of the Commission, because that's the big trigger to get into supported, is that your industry by its very nature is having typically rates of pay that are considered.
And then you get into that famous argument about what Justice Ross described what low pay was, which I think he said historically now is 2/3 of the
median
wage. Yeah, I'm not sure where teachers on award rates would fit with that. I suspect most independent schools are paying way above that, so it might be a different
maybe
issue.
Single interest.
Indeed. So you kind of get the scheme of it, don't you? You get the scheme that you've either got your own agreement or you're exposed to an industry agreement. And once you're in an agreement, unless you're going broke, you're pretty much there. So we're moving you into a world where the government's trying to get what am I putting it? Everybody on an agreement.
Yeah.
Do you agree with that?
And that's the goal.
That's the goal. That's the goal.
I'll very quickly just move through industrial action because we do want to get to the rest of the questions. There's not a lot to say here. There was going to be significant change to this space, which is why you'll see something crossed out quite deliberately. There was going to be some big shift in when industrial action could be taken. That's now gone. We're back to the old rules. The big shift here is that every time a union files for a protected action ballot order, there must be a conciliation conference convened. It must be held between the filing of the application and the declaration of the results of the ballot. And so really what you're talking about is a mandatory process where everyone goes into the commission to try and see if the matter can be resolved. That's the big shift here. There's some ancillary provisions about working out notice periods for industrial action for multi-employer bargaining. But other than that, the rules are broadly the same. There is also an addition of the types of persons who can conduct protected action ballots. But again, that's not really going to affect the employer in terms of their own process.
But there is that nice little trick about whether a union official doesn't turn up to the conciliation. And if they don't turn up, then they can't take protected industrial action.
They'll come. They'll come. They'll come. Tamsin, they'll come. So the question I got asked yesterday, and I was trying to find this, but I couldn't find it. So we hold the conciliation conference. Doesn't seem to be anything stopping them continuing to hold conferences.
No, you can keep holding conferences.
Yeah. So you could have a very interventionist member of the tribunal saying, well, you're here now.
Yeah.
Yes.
You're going to stay.
Yeah, all the commission has to do is trigger one conference before that results are declared. But like with anything in the commission, you can keep coming back if the process is constructive.
So you could have a non-interventionist tribunal member who does it as a matter of form, or
Yes.
a very interventionist member of the tribunal says, well, I'm going to keep trying to sort this out.
Yeah, and I think when you think about the protected action ballot orders, I think they are going to be dealt with differently to the 240s. I think it will be more process-based because they're going to have to get through so many of them.
Yeah.
That I think this will be a more turn up, have a crack, okay, we're done. If you're interested, come back.
Parvo applications have doubled year on year, and I reckon they'll double again.
And they need one for each employer in a multi-year.
In a multi-each
That's
employer.
only just making it even bigger.
Well, you imagine if you've got 20 employers at the table, you're firing off 20. Gender equity reforms, I love the way you say that. I'm going to be really, really fast because I know that certain of our clients are very interested in this, and we've already spoken to most of our clients who are interested. So just remember that the legislation has always had very targeted provisions dealing with gender equity on pay. And what the audience need to understand is that there's some quite material refinements of those, and they're really on that box on the left-hand side. As you saw right at the beginning, there's actually going to be specialist panels now set up. I'm quite anxious about this. I don't know why there's a need for it. We're in an arbitral jurisdiction arbitrating the industrial merits of a case. I'm not sure why I need an academic in women's studies sitting on the bench, because that academic, you're going to probably challenge me, I'm not sure. That academic turns up as a witness anyway, and it's probably turned up in every case.
But now they get to make the decision.
And now not only do they used to turn up as a witness, they now sit on the bench and make the decision.
I have a sense this is a part of the Greens agenda. They kept asking this during the debate.
Right.
You know, what academics are you going to put on there? How many academics?
Yeah. Well, it's ironic because I suspect I'm about to appear in front of an academic who I've cross-examined 3 or 4 times, so it'll be interesting. The big ticket change is that historically in these equal remuneration cases, you were basically saying, look, there's a group of men and women, or there is a man and a woman. It could have been actually on a single individual basis. They're doing work of equal or comparable value, and when I compare them, they're not actually being paid the same, and there's no good reason for it. The notion of that comparator has now evaporated. So this is a jurisdiction which is going to live on the notion of what we might call gender-based undervaluation. The aged care work value case that's just been run before all of this looked at the notion of gender-based undervaluation. It's always been said to be available as an argument for work value increases. There's a general presumption in the Fair Work Commission that, and it's not my word, so don't attack me if you don't like the word. There's a notion that the Commission's identified and the academics in the literature identified as women's work. It's not a phrase I'm particularly fond of, but
female dominated.
Well, I think it's suggested to be work of a domestic or caring nature has been systemically undervalued, not just in the workplace, but also at a government funding level as well. So the bottom line is that it's, put it bluntly, it's going to be easier to run gender-based work value cases. It's going to be easier to run equal remuneration claims. Now, I suspect right now the people who normally would be excited by this are actually in that supported bargaining stream, trying to work out how to get something going in that stream. And I don't think they'll be jumping back to this anytime soon, because I think the other stream is probably where they'll get the funding with the government and so forth. But just be aware this is alive and sitting there. The one area I'm interested in that might actually kick off, this might be something that pops up in the retail sector. It's only marginally female dominated. It's 54% to female, but I suspect that this might be something where we might see something come up in the retail sector. So it's changed. It won't be an area that will affect most people, and for those people who really are alive and well in this area, I think supported bargaining might actually take precedence.
Pay secrecy.
I don't know why you got this.
It's my favourite.
I know it's your favourite. It's his favourite.
Yeah. They're now effectively pay secrecy clauses. If you're seeking to put one in a new contract, they're now banned. They will automatically be deemed invalid or of no effect. But the big thing is, from the 7th of June next year, it will become an actual offence to include one. So make sure they're taken out of your standard contracts or your templates, because the penalty is pretty big at $63,000. If you already have
breach, probably.
Yeah, exactly. If you have a pay secrecy clause already in an existing contract, it continues to operate until you vary your contract in some way. Now, our assumption is that if you're changing someone's wages, you're probably varying their contract. So as soon as you do that, the pay secrecy provisions will no longer have any effect.
We'll have to chat about that.
That's certainly the view of the department.
That's certainly the department. I reckon it would be the view of the department.
If you have a pay secrecy clause in an EA for some reason as well, it's also of no effect automatically.
I've never seen one.
No, neither, but it's in the bill. It's this new right, effectively, that your employees will have to not only ask others about their pay, but to choose to disclose or not disclose their own rates of pay. So as you can see, again, just that action item, make sure that you're reviewing your standard contracts, make sure you're not including it going forward, particularly from the 7th of June, make sure it's not in there.
So the question I got asked the other day was, okay, I can't have a clause that says you cannot share this, but can I have a clause that says something else other than cannot?
It's about the disclosure, so you can't limit the disclosure.
Could I condition how the disclosure occurs? I need to be cautious not to be disclose it in a way that's detrimental to the interests of the company. I'm raising it now because it's interesting. So I've had quite a few people come to me in the last week and say, okay, I've got to cross this clause out.
Yeah.
What could I do?
And we'd have to look at the wording from memory. And it's worth looking at, but from memory, I think it talks about prohibiting the disclosure. So
it's just quite defined. I thought it was quite,
I suppose, though, if you're putting a condition, it's a form of prohibition in certain circumstances. Yeah. So once you start prohibiting doing it in a particular way, I think it's prohibited.
But you could have a general duty to not disparage the company in your contract, right? So you could kind of get through the back door.
Yeah, in other words, my pay's shit.
Well, that could breach other things. Yeah. But the actual disclosure is, it's now a right. It's a workplace right. So this is the other thing.
General protection.
Forget the prohibition part. There's a workplace right, a right to disclose. So I don't think you could get too clever, because even if you got around the prohibition, you can't get around the workplace right.
And my view about this, and we share this view a lot, my view is that the modern generation used to tell each other what they got paid anyway.
We use social media, but yes.
Yeah, well, yeah, thanks, Tab, for that. That's really generous of you. But my view was that, and my experience has always been this, is that I've always seen people use this to their own devices. So if it's to my interest to tell you I'm paid less than I actually am, I often say that. And if it's to my interest to tell you I'm paid more than... So my anxiety about this has not been pay secrecy clauses. My anxiety has been the fact that sometimes people are mischievous and actually tell people they're paid less or more than they're actually paid, which causes lots of HR problems in the business. So it's the modern world.
Yeah.
It's
the modern world.
It's gone.
It's
Last but definitely not least, sexual harassment changes. Obviously, we had the Respect at Work changes which have gone through. They went through just before we had the Secure Work Bill go through. Interestingly, though, those haven't actually yet got royal assent. So your positive duty hasn't yet commenced, but it's definitely imminent. And I'm sure that Kate Jenkins is just dotting the I's and crossing the T's, and we'll have it probably before Christmas, if not early in the new year. Under the sexual harassment changes, though, under the Fair Work Act for the first time, we have an actual prohibition on sexual harassment in the workplace. So before it sat in all the discrimination laws, now it actually sits in the Fair Work Act. Hopefully everyone recalls at the end of last year, we had a new stop sexual harassment order that was introduced, basically mirroring the bullying stop bullying orders we have. That is really only something that occurs that you can get for the future type conduct. You're trying to stop the conduct occurring in the future. There's also no money in it. So we haven't seen that many cases, to be honest. They will continue to operate, except they're just extending them to prospective employees. The new function that's been given to the Commission, though, is to deal with just general complaints about sexual harassment, and they're able to deal with it in a very broad manner in terms of conciliating or mediating. They can't arbitrate, though, without consent. But similar to the existing provisions that exist in discrimination law, if after you can't come to an agreement in the Fair Work Commission, if you'd like to go off to the federal court and actually kind of thrash it out there, within 60 days you can. And this additional point just at the very end that I think is very important, the Fair Work Ombudsman will also have the power to investigate and bring civil proceedings against individuals. The other thing that's a bit different in this that we haven't seen, at least in the discrimination space, is the ability for the unions. We have seen in the Respect at Work changes now, but also now under the Fair Work Act, the unions can bring a claim and multiple employees can bring a claim at once. Collectively, yeah. Particularly, I would assume it'll be against the one individual or the systemic type problems, but we might see that power of the collective. Well, we haven't seen it before in sexual harassment.
As an employer, in terms of responding to the positive duty, what have I got to do?
Well, a variety of...
Ring you.
Yeah, ring
you.
We
and get your kit.
Yeah. We think there's about 7 things you need to do or needed to have updated. The big thing is, though, that if you've got policy and training and it doesn't currently cover sex-based harassment or a hostile workplace, you at least are needed to, as a minimum, update.
Yeah. But Tams and I have a very similar view that if you've just got a policy or even policy and training, that's probably not enough to discharge your positive duty. We've talked about prevention plans, risk assessments. Tams, and you're a big fan of some pulse checking of the organisation from time to time.
Understanding what your problem is.
In terms of surveys. So, but as Nigel mentioned, Tams has got the kit's almost there that people can pick up and use, and we'll have that available for clients very shortly.
So if I was a massive business, your kit's informative and they will probably build on it.
It's built for the small.
If you're a middle-sized business, your kit possibly could just be straight off the shelf and used.
Yeah, well, it's built for the small, but the medium can definitely use it. If you're a bigger guy, the test is reasonable and proportionate. Okay. So the proportionate part, you might need to tack on a few more things, but it's definitely giving you the essentials to work off.
So, I mean, I look at this, and to be fair, and we've had this debate over the years, Liz and I. My view is that if you can resolve a dispute in the Fair Work Commission rather than the federal court, my view is that's a good thing. You sometimes think that's a bad thing. So the jury's out on this, I suspect.
Yeah, I mean, general protections is the classic example. Yeah, you don't want that resolved in the Fair Work Commission because a court is going to have a much more rigorous approach to the test. Yeah. I mean, the other thing for employers is they need to think strategically about the litigation, about how it's going to run, about court processes and whether they better serve the employer's interests, about commission processes, which are much more informal, much faster, whether they put you in a better place to win the litigation or a worse place. In many senses, whilst you might get it done earlier, the better question for the business is, am I more likely to win the litigation in the commission or in the court? And to be honest, it depends on the matter and it depends on the type of issues in dispute, and that'll be your answer.
Yeah, and it might be that I put my HR hat on and say, well, rather than win litigation, how do I solve the problem?
And what's my reputation?
And what's my reputation? Yeah. So it might be a different issue. Yeah. So here we go. You ready? I think we've gone a little longer than I hoped. I wanted 15 minutes, and I've got about 10. So just bear with me. Pay secrecy. Do I have to reissue contracts now?
Nope. They just null and void, don't have any effect. If you put one in, but bear in mind, if you put one in after June, you're in trouble. If you've got an existing contract, as soon as you vary that contract, that term will have no effect. So the minute you give everyone pay increases in June next year, it will have no effect, but currently it continues to run.
Until you vary the contract.
Until you vary the contract,
right.
Yeah.
Okay. I'm an Australian Post licensee. They're smiling. Look at this. I employ fewer than 15 staff. can I be subject to multi-employer bargaining?
Not with less than 15.
So because the 20 rule would apply.
Oh, unless it's supported, but it's probably not going to be a supported bargaining stream.
It's not going to be a supported bargaining stream. I couldn't see it. But
good point though. There's this new 50 number that people have thrown around that Pocock added in. Do we just want to explain what the 50 is?
So the 50s, I don't think it's going to have a huge application. So this is if you're between 20 and 50, there is a presumption that you don't have reasonably comparable interests to the other businesses. So that presumption needs to be defeated. But other than that, you're subject to the
So it didn't really do us any favours.
So no. So really the test for automatic exemption is 20.
Yeah.
Okay. I've got a fixed term contract expiring on March 2023. Let's call it the 1st of March. Can I extend it?
Yes, you can, and you could extend it for 4 or 5 years, however long you wanted. You just be careful that as soon as it expires after the 7th of December 2023, that time period that it's run for is going to be a part of the consideration for the next extension.
This is a good one. I'll let you start, then I might join in. But this I love this question. It's really good. Somebody has created a multi-employer agreement for my locality. For my locality, you might want to give an example of what you think the locality might be. Would I be obliged to join the enterprise agreement?
I think regional multi-agreements is a really interesting thing. I could see this being an area of attraction. I don't know if the unions are seeing this as their priority, but you could certainly see
this is the Port Douglas enterprise agreement that you and I talked about.
The Orange enterprise agreement, the Dubbo enterprise agreement for all retail businesses in that area. Can I be forced into it? Well, the answer is yes, but again, those prerequisites need to be met.
I could be brought into it through the authorisation stage and the bargaining stage, or I could be brought into it later through the roping in stage. However, if I've got an existing EA, the answer's no.
That's right.
And if I'm employing less than 20 people, the answer is
no.
No. So subject to those criteria, you could find yourself subject of an application either to be at the table to begin with or roped in later on. I'm with you because I've been talking to this in the last few weeks have been fascinating because we've had no real IR reform in this country for a very, very long time. I've been talking to some people regionally about that very issue. I'm talking about employers, not unions, who actually want to get back to something that is suitable for their tourist area. Of course, the problem you've got still is you got to pass the boot.
Yes, that's the thing.
You got to pass the boot. It's just a shame that multi-employer bargaining didn't give you greater flexibility than having to pass the boot again.
Yeah, and I think when you look at how the boot operates, it's the businesses are not going to necessarily get, without a really different approach being taken to the boot test, you're probably still not going to get that much benefit than just pulling on the award.
So, interesting question. The 20 employee small business hurdle, does that mean that the definition of small business in the Act has changed generally?
No.
So I've now got two definitions.
It doesn't use the word small business. So the 20 is just a number.
We're just using the phrase
small business. We're using the phrase small business. The Act, when the Act talks about a small business employer, that is a 15-person headcount.
So that's still relevant for unfair dismissals?
Unfair dismissals. Redundancy, they're the two primary ones. The multi-employer test is just 20 employees. It doesn't use the phrase small business employer.
Tamsin, what steps would you suggest we take apart from training and policies to ensure we're providing an environment free from sexual harassment under the new laws?
Well, as we've discussed or mentioned earlier, one, you need to do a risk assessment. You need to look at your business and consider where actually are the risks of sexual harassment. I know my immediate thought used to be, well, I can't spot a sexual harasser, right? So how can I actually do a risk assessment? But it's so much more than that. For example,
did you look at him when you...
But say you've got a bar, for example. This is my quintessential example. I've got a bar. What more can I do to stop sexual harassment? Well, maybe I've got a policy that
We've got clients who've got bars.
Yeah, well, I've got a policy that I ban people who engage in inappropriate conduct. I make sure I've got physical structures between people. I don't have people working alone. I make sure I've got a room people can go to if they are in trouble. All of those extra things. So risk assessment, 1. 2, like get a pulse test on what the lay of the land is in your workplace? Have you surveyed people? Do you know you got a problem? Have you got a communication plan? It's no good having a policy if nobody knows where to access it. I find that's the big one. People just slap it on a website and think people know. The expectation now is that your employees know the policy, they know where to locate it, and they know what happens under it.
Yeah, but there's a difference between having a policy and actively applying a policy.
Correct,
and that's what we're now moving to.
And the next thing is you need to actually apply a policy, and that's all a part of this thing that at least the expectation in Victoria, who's had the positive duty now for 2 odd years, is that you need what they call a prevention plan. And I think that's everything wrapped up together so that you're on at least a yearly basis checking in and saying, okay, have we had problems? What do we need to do better? What other risks do we need to manage in a better way? And you need to have, despite the fact the person said don't want to care about training or policies, one big thing in Victoria is that they've said that training for HR managers, people of the more senior level, needs to be in person at least every 2 years. And I think in person means in some way interactive. So just not a click button through the internet. You could still do it via Zoom or Teams or whatever, but it can't just be a click through scenario.
I think most of our, what I would call switched on clients do that already.
Yeah, absolutely.
Now, I'm very conscious we're about to run out of time. I've got one last question because it's a really great question. And Annabelle, thanks for sending it in. Do we have to put a clause that lets employees know of their workplace right to ask others about their pay in contracts?
No.
It's just that we can't say you can't tell people.
That's right. Just interesting, there's not only a workplace right that you can tell people, you also have a workplace right that you can ask others.
Yes.
But so these are rights that you have, but then there's no requirement to actually put them in the contract. No.
Thanks very much. Look, thanks for staying with us. I know that we'll probably get, as we did last time, a lot more questions sent to us after today. As always, please reach out. There's quite a bit of talking to be done with a lot of people before Christmas. We're currently coming out and making presentations to a lot of corporations individually, some of them on all of it and some of them on key parts. Please reach out if you need that, and that would assist you. Tamsin, thanks.
Thank you. Thanks for having me.
Lou, thanks.
Thank you. Have a Merry Christmas and Happy New Year
to
our listeners and viewers, and there'll be more next year.
Yeah, and take care, and we'll see you soon, hopefully. Have a really safe Christmas.